This is Colin O'Keefe checking in for LXBN TV. On December 28, 2012, Michigan became the fourth state to enact a social media password protection law for employees. Joining me now to explain the law and why it may not be such a great idea is Jason Shinn of Shinn Legal and the excellent Michigan Employment Law Advisor. Jason, first off, give us the basics of the law. What exactly does it forbid of employers?
Colin, thank you very much for that introduction. You are correct. Michigan passed what is referred to as the Internet Privacy Protection Act. It was signed into law by Governor Snyder on December 27, 2012. This act applies, broadly speaking, to employers and educational institutions, so colleges and universities. Now, with respect to employers, there are two broad restrictions that are imposed. The first is employers cannot ask an employee or a job applicant to provide access to an internet-related account, essentially a social media account such as Facebook, LinkedIn, Twitter, things of that nature. Employers also cannot insist on or ask an employee or job applicant to allow that employer to observe their social media account. So I can't ask an employee, an individual, to sign in and then peruse over their shoulder their account information. And the third restriction is an employer cannot ask an employee or job applicant to provide any information that would allow either of the preceding situations, to either directly access or to observe an account. Now, the second restriction imposed upon employers under this act is that an employer cannot take an adverse employment-related action against an employee or applicant for failing to do any of the preceding in terms of allowing access to a social media account.
And second, you wrote that you're really not a fan of this new law. Why do you think it misses the mark?
Now, I've been critical of this law, and going back to when this law was first proposed back in March of 2012 by Representative Nesbitt, the law as proposed did not have any restrictions, and the concern was that logistically it simply was not practical in the context of the employer-employee relationship. I actually wrote a post on those criticisms and shared that with Representative Nesbitt's office. After a follow-up phone call from the representative's office, there were a number of exemptions that made their way into the final law that was signed into law by Governor Snyder. Now, with respect to those exemptions, there are two that are important. One relates to investigations, and under that exemptions, if an employer has reason to believe that information on an employee's social media account it's necessary to investigate that information because of compliance with an existing law or regulation, or, and this is an important or for employers, if it relates to workplace misconduct, then an employer would be permitted to have some degree of access to that social media account. The second exemption, and there are some other exemptions, but the second important exemption has to do with if an employer has specific knowledge, and specific knowledge is the word used in the statute, that information belonging to the company, proprietary information, customer list, things of that nature, has been transferred out of the employer's work environment to an employee's social media account, then an employer would have an exemption to investigate that misconduct. Now, in terms of being critical of the law, with these exemptions, it makes it tolerable for employers. I think without them, it was logistically going to be a nightmare. But anytime you have additional regulations imposed on employers, I think the question always has to be asked is, what is the problem that needs to be solved? And in this particular instance, this statute, in my experience, is a solution looking for a problem. And what I mean by that is employers, by large part, are not looking to this sort of fine-tuned, granular investigation of employees in terms of asking for access to social media accounts. One, from a practical standpoint, most HR professionals that I've talked to simply don't have the time to get down in terms of this level of detail. And second, I just think that employers that are thinking about doing this, they step back from that cliff and realize it's not a good idea for any number of reasons that I've discussed on my blog, in terms of compliance and potential discriminatory acts that can give rise for this sort of investigation. So, having said that, I'm still critical of the law. It's another hoop that employers need to jump through. I don't think it's a hoop that's necessary. I do applaud Representative Nesbitt and those that were instrumental in getting this passed in terms of looking to make sure that Michigan employees are protected and to make sure the Michigan workplace remains productive. However, at the end of the day, I'm just not convinced that this was a problem to begin with.
Again, that was Jason Shinn of the Michigan Employment Law Advisor. For more of his insight on this new law, visit MichiganEmploymentLawAdvisor.com, and for curated commentary from the LexBlog Network's thousands of authors, along with more video interviews, visit us at lxbn.com.